North Carolina has a lease termination framework that's moderately landlord-friendly, but with specific procedural requirements that you must follow precisely. The governing law is found in North Carolina General Statutes, Chapter 42, which covers landlord and tenant relations, including the Residential Rental Agreements Act in Article 5 and the eviction procedures in Article 3. Let's start with no-cause termination. For month-to-month tenancies, North Carolina requires either party to provide at least 7 days written notice before the end of the rental period. That's right, just 7 days. This is one of the shortest no-cause termination notice periods in the entire country and gives North Carolina landlords remarkable flexibility to end month-to-month arrangements quickly. However, the lease can require a longer notice period, and many North Carolina leases do specify 30 days. So always check what the lease says before relying on the 7-day statutory minimum. For year-to-year tenancies, North Carolina requires 1 month's notice before the end of the annual term. If proper notice isn't given, the tenancy may automatically renew for another year. For fixed-term leases, the lease expires at the end of the agreed term without additional notice required. If the tenant remains after the term expires and the landlord accepts rent, the tenancy converts to a month-to-month arrangement. And at that point, the 7-day notice period applies unless the lease provides otherwise. For week-to-week tenancies, 2 days' notice is required. Again, one of the shortest in the nation. Now let's cover termination for cause. For non-payment of rent, North Carolina requires the landlord to provide a 10-day demand for rent before filing for eviction. Under Section 42-3, the landlord must make a demand for rent and allow the tenant 10 days to pay after the rent becomes due. If the tenant pays within the 10-day period, the tenancy continues. If the tenant doesn't pay, the landlord can proceed with filing a summary ejectment action in small claims court. Here's an important detail. The 10-day period runs from when the rent becomes due, not from when the landlord delivers the notice. So if rent is due on the 1st of the month and the landlord makes a demand on the 5th, the 10-day period still started on the 1st. By the 11th, the landlord can file regardless of when the demand was actually made. However, best practice is to deliver a written demand as soon as possible after rent becomes due to create a clear record. North Carolina also has a provision regarding late fees that's relevant to the non-payment process. Under Section 4246, landlords can charge a late fee of up to $15 or 5% of the monthly rent, whichever is greater, but only if the fee is specified in the lease and rent is at least 5 days late. The late fee cannot be used to accelerate the eviction timeline. It's a separate financial obligation. For lease violations other than non-payment, North Carolina's framework depends on the nature of the violation and the terms of the lease. The state does not have a detailed statutory cure period for most lease violations, the way some states do. Instead, the lease largely governs. If the lease includes provisions for termination based on specific violations and specifies the notice and cure requirements, the landlord can enforce those terms. For material breaches that the lease doesn't specifically address, the general approach is to provide the tenant with written notice of the violation and a reasonable opportunity to cure before pursuing eviction. What constitutes reasonable depends on the nature of the violation. Courts evaluate this on a case-by-case basis. For serious violations, including criminal activity, drug offenses, and conduct that threatens health or safety, North Carolina allows the landlord to pursue eviction more aggressively. The landlord can file a summary ejectment action based on the violation, and the court can schedule a hearing quickly. North Carolina courts treat drug activity and violent crime on rental premises as grounds for expedited proceedings. North Carolina has a specific statutory provision addressing criminal activity. Under Section 42-59, if a tenant or a member of the tenant's household engages in criminal activity that threatens the health, safety, or right to peaceful enjoyment of other residents or persons residing in the immediate vicinity, the landlord can terminate the lease. The landlord must provide notice, and the court can order eviction based on the criminal conduct. One thing that makes North Carolina's eviction process notable is its speed. The summary ejectment process goes through small claims court, and hearings are typically scheduled within 7 to 10 days of filing. If the court rules in the landlord's favor, the tenant has 10 days to appeal to district court. If no appeal is filed, a writ of possession is issued and the sheriff carries out the eviction. The overall timeline for an uncontested case can be as short as 3 to 4 weeks from filing to physical removal, making North Carolina one of the faster states for the eviction process. If the tenant does appeal, the case moves to district court for a trial de novo. During the appeal, the tenant may be required to pay rent into the court to remain in possession. This requirement helps protect landlords from tenants who file frivolous appeals simply to delay the eviction. North Carolina also has a specific provision for holdover tenants. Under Section 4226, a tenant who remains in possession after the lease expires or after a valid notice to quit has been served is subject to summary ejectment. The landlord can file immediately without providing additional notice beyond what has already been given. On the tenant side, North Carolina provides several grounds for early termination. If the landlord fails to maintain the property in a fit and habitable condition, as we covered in our North Carolina habitability video, the tenant can pursue remedies including lease termination after providing proper notice and allowing the landlord time to make repairs. Active duty military members are protected by the Federal Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. North Carolina has a significant military presence, including Fort Liberty, Camp Lejeune, and multiple Air Force installations, so this provision affects a substantial number of tenants in the state. North Carolina enacted protections for victims of domestic violence and sexual assault under Section 4245.1. A tenant who is a victim of domestic violence, sexual assault, or stalking by someone who is not a co-tenant can terminate the lease by providing written notice along with documentation. Qualifying documentation includes a valid domestic violence protective order, a criminal court order, or a signed statement from a service provider or law enforcement officer. The tenant must provide at least 30 days' notice, and the landlord cannot charge early termination fees or penalize the tenant. North Carolina also allows early termination in certain situations involving the death of a sole tenant. If the only tenant on the lease dies, the estate or personal representative can terminate the lease with proper notice, and the estate's liability is limited. North Carolina strictly prohibits self-help evictions. Under Section 4225.6, landlords cannot change locks, shut off utilities, remove doors or windows, or remove the tenant's belongings to force a tenant out. The penalty for self-help eviction is significant. The tenant can recover actual damages and reasonable attorney's fees. Courts in North Carolina take this prohibition seriously, and a landlord who engages in self-help will lose credibility in any subsequent court proceedings. One practical consideration for North Carolina landlords: the state has seen rapid population growth, particularly in the Charlotte metro area, the Research Triangle region, and the Asheville area. This growth has put pressure on the rental market and increased the volume of landlord-tenant disputes in the courts. While the eviction process is still relatively fast in North Carolina, landlords in high-growth areas should be aware that court calendars may be busier than in less populated parts of the state. North Carolina requires landlords to return the security deposit within 30 days of the tenant vacating the property. The landlord must provide an itemized accounting of any deductions. An important nuance: trust account regulations require landlords to hold security deposits in a trust account at a licensed bank or savings institution in North Carolina, or furnish the tenant with a bond. Failure to properly hold the deposit can result in the landlord losing the right to retain any portion, regardless of actual damages. For the complete guide to North Carolina lease termination laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.